All right. Welcome, everybody, to our live legal update. We are live now after resolving some technical difficulties, but everything is good now, and we're glad that you can join us. Today's presentation is going to be focused on COVID-19, the new executive order for stay at home that extends it, changes it a little bit. And primarily how this affects things like meetings and elections and the collections process, because that has had some things changing to it. And then a couple of other topics that have just been a little bit different from the past month's presentation that we had. So we want to thank you guys for coming here from the comfort of your own homes. All of us put on shirts with collars here today instead of sweatpants and pajamas, although I'm sure all of you are in such comfortable attire, and there's nothing wrong with that. And for those of you that did dress up, what are you trying to prove? So we'll start off the presentation. Just let's do some introductions. So we'll start off with the left side, which is Gabriella Comstock, and then we'll go to Pat and Adam. So, Gabby, start us off.
Well, actually, I think my name is Gabriella Comstock. I'm with Q and Moody. I believe, Pat, you're going to start us with our discussion once we get to it on the elections and meetings, and I will kind of jump in later when we talk about some of the miscellaneous topics.
That's right. Hi, I'm Pat Costello. For those of you that don't know me, first and foremost, we all hope that everyone is staying healthy and everyone is staying safe. Throughout this discussion, we are going to have three different areas that we're going to cover. I'm going to be covering meetings, Adam's going to be covering collections, and Gabby's going to be covering everything else you could possibly think of with an emphasis on common facilities and common areas and how associations and boards should approach addressing those issues. To start off, though, I think there are some things that we discussed as a group on Friday that maybe are important, and I'll attribute this quote to Gabby when we're thinking about all of these things. Just because you can do something, that doesn't necessarily mean that you should do something. So I think a lot of our focus is what is the best way to approach running the associations, handling the association's business, but still focusing on the function of the association and what its purpose is and what its limitations are as well. I don't think we can discount using common sense. If it doesn't seem to make sense, we should probably either get a second opinion or approach somebody else and say, is this really the way we should be doing this? Because and this kind of goes into my next comment, work within the framework, be creative, but don't necessarily look for shortcuts. And if something seems unsafe, it probably is, and we should try to avoid it, okay? So with that in mind, the questions that a lot of lawyers have been getting lately have, what do we do about our meetings? And we're going to break this into really kind of two categories. The first one we're going to focus on is membership meetings.
All right, Pat, first, before we get to that, can we get a brief introduction from Adam and then jump into meetings and everything?
Sorry about that.
Of course. So last but not least, my name is Adam Kahn. I'm an attorney with Levenfeld Pearlstein. I work in the Community Associations Practice Group, as do the other panelists up here focusing on community association law. And Pat, thank you for the brief pause. I'll let you have the floor back.
Thank you, Brandon. I didn't mean to get too deep without
no
or
problem.
Pontificate too much longer. So everyone who's listening to me, I appreciate your indulgence. But when we're talking about meetings, I think it's critical to remember, though, that there are two different types of meetings that associations have. And sometimes the lines get blurred, but even right now, it's very important to remember that there are board meetings and that there are membership meetings. And most of the meetings that we understand and we talk about are going to be board meetings. We're going to talk about what's membership meetings right now, and specifically what about annual meetings? Because more and more associations are starting to address the issue of our annual meeting is coming up. What do we do about it? How do we proceed? Can we proceed? Should we not be proceeding? And those questions aren't as simple as they normally would be. Part of the reason why they're not that simple is because of the public gathering limitations imposed by the executive order. So normally when we think about an annual meeting, even though we might say, oh, nobody ever comes to our board meetings. Yeah, but people generally come to annual meetings, and that's when the annual meeting, when we elect the board of directors. So outside of amending governing documents, possibly adopting rules and regulations, we don't really think about where members otherwise get notice other than the annual meeting. So the first question is, should we proceed? And I think you need to look at a couple of different things. One, can you do it safely? Is there any way that the annual meeting can be conducted safely? Two, is there sufficient technology available to the association to be able to conduct an annual meeting? Have you adopted other protocols, such as balloting or maybe electronic voting, in advance, which would allow an association to easier conduct an annual meeting? It's going to be different for every community. Some communities are going to say we have 16 condominium units. Everybody can, we have adopted electronic voting. We can do this virtually. We're all in the same building. Others are going to say we have 682 units. We don't have electronic voting. We don't use balloting, and we use mail-in proxies, and we always meet at the library. That might prove a little bit more difficult when the library is closed and people can't actively participate in that. So should we proceed? I think we need to focus on a couple of different things before making the determination of yes, definitively have the annual meeting, or no, definitively cancel the annual meeting. Look at the governing documents. Figure out what requirements the association has that may be specific to your community for purposes of conducting annual meetings. Some bylaws actually provide the agenda for the annual meeting shall be this lengthy list of items. You should probably take a look at it and determine whether or not you can accomplish those virtually. We are not encouraging, and I am specifically not encouraging, anyone to engage in a public gathering annual meeting at this point in time. I don't think that makes any sense given the governor's order. And I do think associations should try to find a way to do it any other way. The question then becomes, well, we always are supposed to have our annual meeting. What do we do? As we were discussing on Friday, and Gabby pointed out, some bylaws say, hey, the annual meeting must be conducted on the second Tuesday in May or something like that. Sometimes there's some leeway or within 30 days, but otherwise it's pretty specific as to when that annual meeting will occur. Some communities actually have great adherence to that annual meeting date too, where they say, for the last decade, we've always had it within days of the first Tuesday of May or the first Tuesday of June. Understand what's in the law relative to that, though, because both the General Not-for-Profit Corporation Act, which would apply to hopefully either condominiums or common interest communities, and the Common Interest Community Association Act specifically acknowledge that your annual meeting doesn't have to hit that date. The Not-for-Profit Corporation Act basically says that the annual meeting shall be held in that same time frame, 15 months from its last annual meeting. And that same Common Interest Community Association Act builds in that same 90 days, which basically gets us 15 months as well. So if your annual meeting is supposed to be held in May, you still have a period of time by which the association voluntarily can extend its annual meeting date for another 90 days before there is actually any actionable items. And only after that 15-month period of time, or 90 days after the last annual meeting date, can then the owners file a petition to compel the board to actually conduct its annual meeting. And I'm not saying avoid annual meetings. I'm not saying ignore annual meetings. I'm not saying don't worry about it for 2020. We'll just deal with it again next year. That is not sound advice. But there are timeframes and I guess buffer periods already built into the statute that will allow the association to extend its time for annual meetings. Get in touch with council, make sure you understand what those are, but I would highly suggest that you use that. This was a little bit later, but I think it's really critical to note in the Not-for-Profit Corporation Act that specifically provides failure to hold an annual meeting at the designated time shall not work a forfeiture or dissolution of the corporation, nor affect the validity of the corporate action. Just because the annual meeting wasn't held in May doesn't mean the directors all go away, doesn't mean the officers change, doesn't mean that the corporation's actions in June and in July, as we're waiting for the rescheduled annual meeting, are subject to question. They are valid. Statutorily, those actions remain valid. And most bylaws and the acts provide that directors serve in their position until their replacement is elected. So even if you had a 2-year term and your term comes up on May 13th, that doesn't mean on May 14th you're no longer a director if you haven't had an annual meeting. You continue to hold that position until the next annual meeting where we can actually have an election. So it's not the end all be all. We don't have to panic that there aren't annual meetings being conducted. Focus again on the safety of the residents and the elimination of large public gatherings, because we've been to enough places. A lot of the places that are public are saying the library is not open now, the meeting room at the police department's not open right now, but other places have clubhouses where in theory they could conduct their own annual meetings if they wanted to open it up. Not a great idea to have 50 people getting together, though, in the clubhouse for the purposes of electing your board of directors.
Now, when we're talking about this and the fact that you're not going to dissolve by not having your annual meeting, this is all stuff that falls under the Nonprofit Act, correct? This isn't something that is different between homeowner associations and condo associations. It's not a Condo Act SECA difference.
Well, it falls on, sorry, now I'm looking at myself staring at the ceiling. It falls under the General Not-for-Profit Corporation Act. There's an analogous provision that's written a little bit differently in the Community Association Act regarding annual meetings. There is no similar provision in the Condominium Property Act, but condominium associations can still revert and use the General Not-for-Profit Corporation Act. Personally, I think the General Not-for-Profit Corporation Act does a better job of explaining what happens when a corporation doesn't have that annual meeting, but the Common Interest Community Association Act works hand in hand with that.
Okay, so then also another question that came up about these, and it may be something that you're planning to get to later or might have been touched on a little bit already, but if the bylaws and declarations have current language that say it must be held in person, then is digital an option, or is there a way to make digital an option? Or would you say if everybody's on board with it, go for it, and nobody raises objection? And after the fact, if somebody says, well, wait, our bylaws said this needed to be done in person, is it defensible, I guess would be a question.
Is it defensible? Probably, because I think if you look at, well, first of all, let's just look at reality and whether or not, a court in 2021 or 2022, when this case finally goes to trial, or 2028 for that matter, would say, I'm sorry, your annual meeting of 2020 was invalid because during the COVID-19 crisis, you decided to conduct it virtually and allow people to participate. I don't see that being a great fear, but I do think there is also some statutory basis too, because when you look at the use of technology sections that are analogous in the Common Interest Community Association Act and in the Condominium Property Act, it has some pretty broad language. And it basically says that they may perform any obligation, exercise any right under the community instrument or any provision using acceptable means of technology. Now, would I recommend that means throw out all in-person meetings and never have an open meeting and only use technology? No, but I think that section could be employed to provide a statutory basis right now, even where the documents mandate an in-person meeting.
Well, Pat, along those same lines, don't you think that because of the time we're in, I mean, clearly when these declarations were drafted and these statutes were drafted, nobody was thinking of a pandemic. Nobody was thinking that we are going to be literally having to stay at home. And so back to your original comment, it's almost using that common sense approach that if we don't come up with a solution, how can these corporations not continue to function? And then that almost would be suggested if we didn't have annual meetings.
Right. I agree, sorry. I agree, Gabby. And one of the things I was thinking when you were saying that is what we're trying to figure out is what's the best way that we can give notice, we can give participation, and we can allow unit owners to the best of the board and the association's ability to participate in the process. And I think if a court were ever coming back years later and questioning the decisions made by an association at that point in time, they're going to say, what did you do? And the more things that we can show that we did, the more advice that we can show that an association relied upon and said, we sent out extensive notice. Maybe the notice requirement is just 10 to 30 days for an annual meeting. And maybe it's just, time, place, location, and you say we can do it virtually. But maybe instead of just mailing out the notice, maybe we do an email as well. Maybe we do a blast. Maybe we do a couple of different kinds of notices just to make sure that the residents fully understand how to participate, how to involve themselves in this. I've even heard one group say, we're going to do a test run on one night just to see if whether or not people can dial in, because as we even found out from this own Skype meeting today, sometimes even when we work on technology one day, it doesn't work the next day. Yeah. So these are the types of things I think that associations can do to ensure some level of participation, some level of involvement, and courts and legislators' favorite word, transparency, just to make sure that it's happening in the open and everyone is fully aware of what's going on. So I do think that we can follow through with it, but the more we can do to protect the process and the integrity of it, I think the better off it would be for the association. And I guess then that gets kind of to the next thing we were talking about. If somebody says, you know what, we understand we have 15 months. We understand we maybe can even buy some more time after that 15 months and extend this, but we really want to have our annual meeting in June. We think it's critical. And there could be some reason. Somebody could say, we've had people quit the board and we don't want to appoint anyone. We want to have an election. We want to have this. So if you're a community that says we need to have this annual meeting, and maybe start thinking about it now, because we're talking about the executive order that exists in May, but it would be probably unreasonable for any of us to say we know what June, July, or August is going to look like, and whether or not all of a sudden there's going to be gatherings at that point in time. So now that it's May, even if your annual meeting is in August, maybe start asking these questions of what can we put into place at this point to be able to accommodate that annual meeting in the event there's gatherings limited at that point in time. Maybe it'll only be 25 people that can gather together, and maybe you have a 500-person community. So maybe we're going to have to figure out how to accommodate these things. Remember, most of what we're talking about in an annual meeting is voting. I mean, when you boil down the rest of the agenda, it's here's the candidates, cast your ballots, here's the people who are elected, congratulations, you're the new board. So while other things certainly can happen in an annual meeting, that's the critical factor. So there's other ways already built into the statute that we can allow people to participate in voting, either electronic voting, understanding that the Common Interest Act and the Condominium Property Act are different about when the process can be put in place. Condo Act requires 120 days in advance. The Common Interest Act doesn't have that requirement. You still need to somehow get a rule in place beforehand, but maybe if you start taking steps in May, you can have that process set up for August or September. There's also the ability for balloting. Again, Condominium Property Act has different requirements. If you want to go to mail-in balloting, the Common Interest Act seems to suggest that that can be one of the mechanisms that you're already used, since it says a member may vote and includes balloting already in there. So look at your election procedures, look at the way that you've done that in the past, and say, okay, if it's August or September and we're still not allowed to have a gathering, how are we going to have our annual meeting? Because we don't want to delay it forever. We do want to continue to go with this process. we do want to have a fully elected board moving forward. And remember, ballots and proxies are not the same thing. So proxies are still a functioning instrument to be used for meetings, but they're not the same thing as casting a ballot. Sometimes we see that mixed up. But look at your documents. Your documents may already provide for balloting, but if they don't, and you're bound to either in-person voting or proxies, think about ways that you can use directive proxies to be able to allow members to actually select candidates and direct people to vote for them. The good news is, built into both statutes is an acknowledgement that if you're using some other form of voting other than just in-person voting, mail-in ballots, electronic voting, and even proxies can count towards the quorum. So you don't actually have to have your 20% or whatever the other percentage, possibly on lower percentages under the Common Interest Act communities, to achieve that participation. I have heard of communities saying, well, we're going to do this virtually, and we're going to actually allow for
Oh, Pat, hold on for a second. Your audio cut out.
both of those acts, and it's time to be creative. I think the focus needs to be, again, on owner participation, on proper notice, and then trying to make it happen. I know we started a little bit late, and I know Adam has a lot of interesting things to say, and I know Gabby has a lot of interesting things to say too. So I won't go longer, but I do want to just talk about one little difference that just recall when I started talking, we were saying that there's a distinction between board meetings and membership meetings. What I said about membership meetings and annual meetings and the ability to delay those, that probably can't happen with board meetings. Both statutes require generally, and most governing documents, there shall be 4 board meetings over the course of the year. There's no provision in there that says, well, you only have to have 2 or you only have to have 1. And in fact, these boards probably do need to meet and find a way to continue to meet during this period of time, or the business of the association is just going to grind to a halt. Know the different notice requirements. If you're conducting virtual board meetings, please communicate to your members the way that they can minimally call in, dial in, log in through Zoom, or participate in this meeting and see the business of the board being conducted. Understand that there's a distinction between the Condominium Property Act and the Common Interest Community Association Act regarding members' participation. The Common Interest Community Association Act actually uses the word must and provides that members must have an ability to participate at a board meeting. So figure out how you're going to accomplish that and allow that, what we traditionally know as owner forum, to continue to exist. Maybe it's, please.
Pat, are you able to hear me?
I can hear you.
Okay. If you can hold on for just a second, we're having a couple of issues with your audio.
But I can still see myself in the corner. Okay. I was just about done, so we can move on to Adam if you want.
I can jump in and add a couple of things too.
Yeah,
to get back on what Pat was saying.
Go ahead.
So the first is, I think it's important that associations look at this as an opportunity. Obviously, no one saw the massive changes occurring due to the coronavirus pandemic coming, but this is a great opportunity to evaluate how you conduct your meetings, to look to adapt new means to allow folks to participate who may not have participated before. If you have offsite owners who just have never been comfortable with the submitting a proxy, this is a good opportunity to take a look at whether you've adopted absentee balloting rules that would allow you to send in votes that way, or perhaps it is more convenient to conduct annual meetings of unit owners and membership meetings of the board via teleconference. This is a great opportunity to try these out. It's a trial by fire, but it's ultimately, I think, could lead to a good long-term impact of just more convenience and more transparency and participation, which at the end of the day is a good thing. So I did just want to emphasize that. Gabby, do you have anything you wanted to add before moving on to the second topic?
I do, not surprisingly, right, guys? I think, Adam, you said it much nicer than I probably would have, because I feel like using the electronic means to conduct a meeting, this is the time to get control of your meetings. Think of all those board meetings, all those membership meetings that go on too long. Think of those meetings where the owners are just given too much of an opportunity to attack the board members. Think of the time where those board members are too long, going on too long and not allowing the owners to speak and voice their concerns. This is our chance to take a step back, learn how to do it right again, and to really make it a more productive meeting and better for the members of the board and also members of the community. The only thing I want to add on the elections is that I think Pat handled it very well in describing the differences between proxies and ballots. But the one thing you want to remember when you're using proxies for your annual meetings, it's a good idea to let the owners know in advance who will be attending that meeting. The manager will be in attendance. The board president will be in attendance. So those are people they can select to designate as the proxy holder, because it doesn't do any good to name me as your proxy holder if I'm not going to be at the meeting. So we want people to have the option to designate who they want, but I believe it's critical now more than ever to let them know who will be there so that their vote can count. And the last thing I just want to say, I think, Pat, you were so right in highlighting the different sections of the acts that clearly show a move towards using technology as the right way to handle such a serious situation. But for those of us, including me, who can be a little technologically adverse or not as knowledgeable, we've got to get out of our comfort zone. And it's not an excuse not to go ahead with that annual meeting because we don't necessarily like to conduct a meeting that way, or it doesn't feel right. This is a new time. And going along, Adam, what you said, it's a time that we've all kind of got to get on board with. And I think while most of us back in March were saying, yeah, postpone your meeting, it's okay. Now that we're going into May and we're still at the stay at home, then sure.
It's okay. It's not the worst thing in the world.
Can we make that happen? Life?
Okay. Now, chat. Now, chat. I'm going to need you to tell me, is the audio okay? Are we all good? And is the stream all better? Is the stream all better, chat?
Brandy, you got quiet again.
Yeah.
I think I got quiet for you guys, but I think I got it good for them. All right. Chat says we're good. All right. So thank you guys for hanging in there. And we're back on our presentation. We're moving our topics a little bit. If you have questions that you'd like us to wrap up and come back around to on meetings and annual meetings, make sure to put those in the chat, and we'll circle back to those at the end of the presentation. All right, so then our next topic of conversation is going to be focused around collections. So this is something that I think has been ongoing a little bit with postponements of elections and eviction actions and everything along those lines. But as far as collecting monthly assessments, even this can be an issue. So, Adam, I think we slated you to kick off this part of the presentation.
Absolutely. So, in sticking with our theme of using common sense, assessments are going to be a big issue, and we would advise and recommend that boards take a common sense approach of being compassionate. Obviously, this is an unforeseen pandemic, but also being realistic and understanding that associations need to continue to operate. They need to continue to collect, because that is the lifeblood of the association. It's how you pay for your ongoing services. It's how you pay for any remediation efforts that are going on in the building. And it's also to protect every owner's investment in the association. So I can certainly understand, a board's temptation to reflexively help out. And, if an owner falls on tough times, the question gets asked, can we forbear assessments? What's the flexibility? And the first thing we'd say is, make sure that you are keeping in mind the reason for these assessments. It goes to cover the cost of continuing to operate the association. And also, boards have fiduciary duties to act in the best interests of all owners. That's going to include continuing to collect. And going even one step further, the Condominium Property Act actually expressly states that boards do not have the authority to forbear assessments. So I think the initial question of, there's this new pandemic, a new economic reality. A lot of folks are not working right now. It's a division that I think some folks may view as akin to the 2008 market correction. Can we forbear assessments? The answer, unfortunately, is no for forbearing, and also keep in mind why these assessments are collected and use a common sense approach of what do we do. I want to mention as well, the governor's order did put a moratorium on residential eviction actions. And that you can see the logic behind that. I can see wanting to protect folks' homes, particularly in a pandemic where we're all supposed to be sheltering in place. We're not supposed to be going outside. So you see the logic in that. But what this doesn't mean is, we are not recommending that boards bury their heads in the sand and do not take action if, someone is not paying their assessments. So the question becomes, well, what can you do in those situations? If someone is not paying assessments, you can continue to, as we've done before, charge late fees for late payments. The idea there is to incentivize with these late fees. No one wants to be hit with a late fee, so pay on time, it's not an issue. You can also file a lien if an owner does not pay their assessments on time. That's the second option. The idea is basically you're securing the association's right to collect. You're securing what's due. You're taking action. Another option is submitting a notice stating, in essence, here's what you haven't paid. You're reminded to pay. Here are the late fees. A quick wrinkle to that is under the governor's order, there is a moratorium on, I believe the exact phrase is commencing a residential eviction action. There is some debate, and it seems the majority view on that is commencing an action likely includes issuing that statutory notice that's required for a condominium non-payment action under the Eviction Act, that 30-day notice. So it's our view as a firm that issuing that 30-day demand is likely an issue under the governor's order, so that cannot be done just during the pendency of that order. But it doesn't mean that you can't send a notice saying here's what's owed, and it needs to be paid, and you can also explain why it needs to be paid. The association needs funds, obviously, and in conjunction with that, associations can and boards should consider working out payment plans as appropriate. If an owner comes to the board and says, it's a really difficult situation, I've lost my job, I don't have income, the board should hear that owner out. And you cannot forbear assessments, but we know that some boards have worked out payment plans successfully.
I have two questions.
One of the issues, please.
The first being, as far as the payments go, or the letter that you're sending, it's not a demand letter. It's a I guess what's the difference between a demand letter and what you're sending? Is this like a reminder, a bill reminder that this is something you'll have to pay? Or what's the difference between that and a demand letter? So I'll let you talk to that first, but then once you've covered that, or once I'll let the other guys, they can jump in on this too. I have another one after that.
So it's a good question. And the 30-day demand is a statutory requirement that starts the clock. You issue that demand, and then 30 days later, you have the ability to file suit. Given that you cannot commence an action anyway, our firm's view is essentially it wouldn't be that demand. It would instead be a document that would look pretty similar to that demand, saying, hey, you're 60 days behind, you owe this amount, these late fees will be assessed to your account or have been assessed to your account, you need to pay, but it would not start the clock on filing an action, which really makes sense because the courts are closed now anyway. And we anticipate even if the courts do open up, shortly, which I don't think anyone has a crystal ball, but if they open up in June, July, there's still going to be a backlog of cases. So it's important to
Adam,
start
don't you think it's your demand just doesn't have a demand for possession? It's just
exactly
a demand for payment, but not for possession?
Yes.
Okay.
So before I get too far afield, Brandon, did you have a second question?
I think Pat tried to say something, and I'm not sure I was able to hear him.
I did not hear Pat. He might be individually muted. Yeah, Pat, you have yourself muted.
There we go.
Hey.
Now I'm on. I was just going to I think Gabby brings up a good point. When we're using the term demand, it's technical and it's not a demand for money. It's actually the demand for possession under the eviction action, much like a landlord would demand repossession of the property under an eviction action. So that's the part that, Adam, you're referring to. We're not going to make that demand for possession of the unit. And that's consistent with the governor's order then, that we're saying people need to stay in their homes. So while we're going to still demand that you pay your assessments and your other common expense obligations, we're not going to link it to a demand for possession of your home.
And I think, Adam, you were right to mention, it's not just your firm's interpretation of the order. And Pat, I know you and I agree with what Adam said too. If you were able to send out that statutory demand for possession, you are in essence initiating the eviction action. And that's the concern that at least our three law firms all have, is that would be problematic for the associations. And I don't think it's just us three that agree with that.
And we don't want any of our clients to be on the wrong end of a judge's decision when we do get back into court to say, hold on, you filed this when? You did this when?
Right.
Because as people become delinquent and as more owners start to find it harder to pay their assessments, we know courts aren't going to necessarily bring down the hammer on those people. So the more, you don't want to give a judge another opportunity to do something to your case that's otherwise very clean on unpaid assessments.
Your point there actually comes to oh, sorry, Gabriella. Your point comes to a question that we have from chat, and also along the lines of what my other question was. The question from chat is whether a line can be drawn in the sand as far as people who were in arrears before the pandemic and lost their job consequently, perhaps. And for those people, can a board require that they have some kind of proof that they've lost their job? And for my point, as far as standing in front of a judge, and you mentioned that judges are going to want to offer some leeway for those people that are in a difficult situation. You guys have brought up a great point last week that we saw something like this before with people losing their ability to pay a lot in the financial crisis 12 years ago. So I guess that's a whole jumble of questions to add in there. But there's this case that people are going to have this difficulty paying, and what's the difference between people that lose their job because of COVID, and even if they were in arrears before, and those that start having difficulty to pay now?
Adam, why don't you address all that, and then Pat and I can age ourselves in a little bit and talk about the comparison with the 2008 issue after you address some of those questions.
Yeah, great. There's a lot packed up in there. The first is, getting the question boards will ask, what proof can we have that someone, is not having the income, or, basically, how do we know that someone isn't trying to get away with not paying their assessments for a time just because there's something going on in the world, but they may still be able to pay? And what we'd say in that situation is, it's really not the board's place, and I don't think the board would want to be asking for financial documentation. It's a lot of confidential information, and just a headache the board really shouldn't have. It goes back to, I think, as we've been discussing, what can the board do versus what should the board do. And I think it's just not advisable for a board to be asking for this type of documentation. It's at best tone deaf, and I think it's really a question of everybody needs to pay their assessments. How do we as a board strategize to proactively deal with this to make sure that the association can meet its obligations on an ongoing basis and is not caught unprepared in case there are a high number of delinquencies, not to harken too far back to 2008, but just keeping that in the back of your mind. With ongoing collection matters, courts are currently closed. So everything is, if something has been filed, it should be assigned a new court date. So to the extent that you believe, your association is midstream with a collection action, that is likely just on hold. Whether a board can make the decision, if someone was in collections before and now they're undergoing hardship due to the coronavirus pandemic, I would say it's still the same financial needs. So perhaps there's some leeway to work something out, particularly in this opportunity where we have this pause right now. The courts are closed, so the case is not going to advance just yet. If you can have a dialogue with that owner and say, hey, can we work out, are you able to work out a payment plan? That's a great outcome. But I think there's going to be a lot of reassessing once that ends. And the onus is on the owners to come forward and say, hey, I've got an issue. I'd like to work something out. It's not necessarily on the boards to say who has an issue. And, I don't think it's really wise for boards to be forecasting that anyway. It's business as usual unless someone raises their hand and says, I have an issue. And in that case, the board considers it on a case-by-case basis. Boards should be consistent. And again, there may be some leeway on late fees, but you cannot forbear assessments. It's right there in the Condo Act. So I think I've unwrapped everything, but I want to at least give an opportunity for Pat and Gabby to say a piece as well.
Well, the only thing I would add is, we did see a lot of this in 2008. Unfortunately, we saw the impact that it had on associations and their inability to collect assessments. And as we were preparing for today, Pat and I were reminded of what it was like. And, we both were saying that you never wanted to be before a judge with a homeowner who would say, I tried to get a payment plan. I tried to talk to the board and they wouldn't listen to me. It's just not going to fly very well with any of the judges in any of the counties. But more importantly, as a board, you're almost losing sight of what your ultimate goal is. And that goes back to, Adam, what you said. Assessments are the lifeline of the association. So if you can start to get something in, get it in. Yes, we always want the full amount. Yes, we always want it as soon as we can. But sometimes we don't always get what we want. And so going back to what Pat said about meetings, this is another example where we have to get a little bit of creativity on our plate, and we have to think outside of the box. We need to work with our owners. We can do it, but that strict approach didn't work in 2008, and I don't believe it will work now either, especially in light of the orders that we have by the governor that we didn't have in 2008. So if we saw in 2008 judges were reluctant to find boards acting in a heavy-handed manner, I feel very comfortable in saying they're going to be even less tolerant of it now after these stay-at-home orders have been in order for a very long time. And you can't look at the offender. You can't look at who is the delinquent owner. You have to look at the balance on your sheets, and you have to look at how do I get that money? And this is going to be a time where you have to just try to be as reasonable as you can with these payment plans.
Yeah. The last point that I would like to bring us back to 2008 is, even though we're just talking about assessment collection now, we know this is going to have other implications too. When people stop paying their homeowners assessments, they might stop paying their mortgage. They might be considering filing some form of consumer bankruptcy. So when boards look at these things, we can't look at them in a vacuum. We have to look at how are all these things and what are the interplays? How do we best protect the association, trying to keep this person in their unit, trying to keep them paying assessments? But just because there's a foreclosure, we can't close our eyes and say, let's not do anything, because we know what happens to associations there. Just because there's a bankruptcy means we can't just sit there and say, there's a bankruptcy, we can't do anything. Associations' delinquency rates are going to increase exponentially, and they'll become very difficult to recover from. So it's really an interesting thing, because we're kind of telling you two different things. We're telling you, be sensitive to what the needs of the community are, be sensitive to collecting the assessments, find a way to keep flow coming in. Yet at the same time, you also have to consider the finances and the expenses of the association. So everyone can't go on a 60-month payment plan right now, because it just won't be able to work. You won't be able to open any of the facilities, and you won't be able to, plow the snow or salt the parking lots or do those types of things. So it is going to be some heavy lifting on the boards to try to accommodate those people. But I think as long as the focus is we're willing to work with everyone to the extent we can continue to bring the money in. We don't want your homes. We don't want your units. We don't want to lease them out. We want to keep you in there, but we need to find a way to get you current and to keep you paying so we can continue to pay the bills for the association.
Well, Pat, I think you brought up a really good point that I almost forgot about, which in 2008 and for a couple of years thereafter, associations that would find a unit in foreclosure, you're right, they would say, oh, I'm not going to go forward in trying to collect the assessments. And the one thing you have to remember as an association is just as you're trying to work with these owners and work out payment plans, so are the lenders. And in fact, most of the lenders, especially those that are FHA financed, they're going to be under a requirement to be working with those homeowners, whether it's through a moratorium or through other guidelines that are established by HUD. But you can't just automatically assume they're in foreclosure, I've lost. No, I mean, Pat, I'm sure you saw it too. We saw a lot of associations really look at it in a case by case, and they came out ahead, and they were able to be okay, even though units were in foreclosures. And then we had the other associations at the other extreme, which said, nope, not touching if they're in foreclosure. And it really bottom line for many years to come thereafter.
Yep, definitively.
I'd like to add to that something. It's a quote I like, and it's basically, hope is not a strategy. It's good to be hopeful, but burying your head in the sand and doing nothing because of this pandemic is not going to lead to good outcomes. I think boards would be wise to be proactive, think things through, be reasonable, be compassionate where you can afford to be, but being compassionate and doing nothing are not the same thing. Yeah. And it takes planning. It takes proactive planning at this stage, which I think leads to another opportunity, and that's that boards should consider their collection policies right now. Things are at pause. It's a good chance to reflect on, is what we're doing working? Is, sending a courtesy notice working, or are we being too lax? And also, if we have any old debt on the books, this is a good opportunity to clean it up. Take a look, speak with the accountant, and see if there's anything that should be written off, because obviously you want to collect everything, but at the same time, when you're looking to obtain financing, when new buyers are coming in, the books and records of the association, the financials are really going to matter. So you're going to want to be proactive, be smart, and clean those up as much as you can. Obviously, you're not writing everything off. I wouldn't recommend necessarily writing off new debts, but it's another opportunity to take stock and look at what can we be doing better right now.
Yeah, that's good advice. The only thing I would say is I probably wouldn't change your long-term collection policy, only because I think right now a lot of people feel very much like I can't afford something and I don't know when I will be able to afford it. So maybe along those lines, what people could do, or associations, is have a little short-term policy and plan, which even if it's just we're going to work with our owners until this moratorium is lifted, or until we have a better idea of financially where we stand, and maybe come midsummer or early fall, then we'll change our collection policy. But right now, most homeowners just feel very much they don't know, they can't see, I should say, the light at the end of the tunnel. So they're going to be asking, like Pat said, for that very long-term payment plan. Well, instead of just outright saying no to that owner and making them feel like, sorry, we're not going to get anything from you, and you as a board not giving your association the opportunity to collect any money, perhaps the better response is, right now, we can give you a 5-6 month payment plan, and then we can revisit it. But at least to start getting some money in, that has to be the key. Get the money in, even if you're going to reevaluate it somewhat later.
So a question from the chat that goes along these lines does the board have to wait for a owner to come to them and ask for a payment plan, or can the board see somebody with a large balance and proactively offer a payment plan?
Oh, I'm interested to hear our different responses. Who wants to go first?
My point would be, don't negotiate against yourself. Yeah. So sometimes it's easier to say, we understand you have a delinquency. We'd be interested in working with you, and let the owner make the proposal as to what working with you means.
Yeah, I agree. I think as a mom of teenagers, you give too much, they're going to take probably more than they should. And I think that you're better off just having that door open and listen to them. Some associations want to go so far as to send notices out saying, this is what we would take. This is what we will consider. I don't think you should do that. I think you just do, Pat, what you said, and just open the door. And we're all adults too, and we have to be responsible too. And I think that it's better to see what they come up with first.
Completely agreed, and I'd add to that, if you have an owner who is in delinquency, 12 months worth of assessments, you also have to be realistic. Is it the case that this owner, how much can they really afford to pay? I think you want to open the door and listen to them, but I don't think you want to proactively say, let's extend it out as far as we can, or, as Pat said, negotiate against yourself. I think that's exactly right.
Well, Brandon had asked the question earlier, what about the person who is delinquent, or was their delinquency started before the pandemic? Do we treat that person different now than we would perhaps the new delinquent owner? Adam, I guess maybe you can address that, what your thoughts are with that.
I think it's a good question. Ultimately, the need for the funds is the same. I think the particulars are going to matter so much. If the owner can come and say, hey, I fell behind and things only got worse. At the end of the day, it's just about bringing money in the door. So I don't know that I would treat it necessarily that different.
Okay.
And as a practical matter, I don't know that the courts are going to treat it any differently either. As to when the debt originated, I don't think you're going to see somebody saying, well, judge saying I'm less sympathetic because this is, a January, February debt, and as opposed to an April, May debt.
Mm-hmm. Yeah, and I also think that that's a perfect time of when the board needs to not look at who the person is, but just look at the numbers. So,
right.
Brandon, do you have any
I
other questions on the topic, or should we go to the next?
Yeah, I think that let's jump into our last kind of what was this, the potpourri, the catch-all that we had. But I think we wanted to start with common areas, and actually a little bit, I think one topic that was in the chat as a question already that I think would be a good one to start with, since we've been talking about assessments already, is this is another can or should question maybe. Can the board refund an amount in assessments that it's not spending on its pool or its fitness center or its any other common area that's closed because of the pandemic?
Okay, did everyone notice both Pat and I went further back in our seat once you said refund?
Yeah, I made a face that I hope doesn't translate.
So I think that the clear answer on that one is no refunds. You still have bills. You still have obligations. You still have a common area that you have to maintain. And I think what's very important for us all to remember with the common facilities is going back to what Pat was saying with meetings. We don't know how long this is going to go on for. We don't know what the next day is going to bring us with our common facilities. And we already have had probably additional expenses for the common facilities during the time that they were open. I would suspect if we're fortunate enough to see them reopen by the end of this year, what your cleaning costs were before probably will be higher towards the end of the year. So no, I don't think you should do any refunds. I believe that you adopted your budget at the end of last year based on those expenses that did exist or that you thought would exist, and they were properly adopted. And it will probably help offset some of these other expenses that are going up and the assessments that you're collecting, which are going down. Pat and Adam, I don't know if you want to add something before I get on to the next part of this.
I think just good boards look at their budget in the totality of the entire year. And while there may be a savings in the summer of not opening a pool and not paying lifeguards, those other expenses, either in terms of delinquencies or cleaning costs or other things, might go up substantially during the course of the year. If you find yourself on December 19th and you note that you saved a lot of money over the course of 2020 and that there's a lot more assessment income than there was expense, great. Pass it on to the owners and reduce the budget in 2021 a little bit with that operating excess income. But I think it would be really premature to start writing checks back to owners at this point in time. And my fear and my concern is associations who do that then find themselves special assessing people come April of next year because the costs and expenses just went through the roof.
Yeah, I mean, I'm still waiting to hear, because the pools aren't going to be open this summer, if the village is going to refund my taxes at all.
Oh, I can answer that for you right now.
Well, and you know what, that is a common question though we are hearing right now is, should we amend our budget? And I know this is a little off of the potpourri topic that we're on, but I think that along the lines of, Pat, what you just said, no, I mean, I don't think boards should be looking to amend their budget right now. I agree with what you said. Let's wait till the end of the year and make those decisions then. Adam, do you have anything to say before we go on to the rest of common areas?
The only thing I'm echoing what Pat is saying is look at your budget in the totality and make sure your reserves are sufficient too. If you're saving $500 on something small, I wouldn't be spending time considering how do we split that across owners. Make sure you're in a solid financial position, knowing that there could be so much uncertainty ahead.
Right. So when it comes to the common areas, I think many associations were concerned about closing certain common facilities, and they waited till the last they had to. And so now, obviously, pools tend to be the most hot on everybody's mind right now, since we're hoping summer is approaching. And so that's a common question. Should we reopen our common areas? Should we open our pools? Should we open our common facilities? Can we follow the phasing of reopenings that the state is going to be and the federal government will be implementing? I think that this kind of goes back to what Pat started us with. Can we do it, and should we do it? And when it comes to the common areas, we all have to think about, what does it really mean to reopen these common areas? Because it opens up such a large can of worms, in my opinion. Once you open up the common areas again, you have to make sure you're cleaning, and you have to make sure you're properly cleaning. And there's a lot of question right now, at least for us lay people. Is it enough what we have in mind as to how we should clean it? I believe that the associations are better off leaving the common areas, the common facilities closed right now. Pools should stay closed. Will my opinion change come June? Maybe. But for right now, they should remain closed. You can take it one step at a time. If you want to reevaluate it each month of the summer, you can reevaluate it. If it's more cost effective for your association to make a decision and stick with it at the beginning of the season, I don't believe there's anything wrong with that. I think it goes back towards everything we've been talking about today. Use a common sense approach, think about the totality of your expenses, and think about what you want to undertake. Because the minute you open those common facilities again, it is hand in hand. How are you going to protect the owners? You may not be assuming a responsibility for their health, but you do have a responsibility to maintain the property that they have an ownership interest in and that they have the right to use. So how will you maintain those pools properly? How will you maintain the fitness rooms? Some associations say, well, we're going to clean it regularly. We have the wipes in there. Okay, well, what happens if Pat goes in and doesn't know that he is carrying the virus at the time? He uses his wipes. Maybe he wiped down the equipment properly. Maybe he didn't. Adam goes in next. Adam gets sick. Adam catches it. It's such a can of worms, and we don't want to give any owner the opportunity to make any allegations against the board at a later date, because not to put fear in anyone, we don't know what litigation is going to come out of this, and not just for associations. We're probably going to see a lot of we already are seeing litigation that's coming up related to the pandemic. We don't know what people are going to say as it relates to, did the associations do enough? And I believe it's the most prudent thing right now to keep those common areas closed and whether we follow state and federal guidelines as to how we phase them to be reopened, I don't know if that'll work for all of our associations. Kind of along the same lines with collections. It's not going to be a one size fits all. It's going to depend on the size of your rooms, on the size of your facilities, the size of your budget, the size of your delinquencies, and your comfort zone with it all. I think that more than ever, you're going to have to take a step back saying, yeah, we can open it, but should we? Should we take that? I don't think boards should do anything more than they have to which could be perceived as taking on more responsibility or liability than is necessary. Do you guys have anything
the
to say on that?
question here that came up about that then is a little disclaimer saying, because we've already got disclaimers on pools saying swim at your own risk, right? Mm-hmm. So let's say it's the fitness center. And I don't know why in the examples Adam's got to be the one getting sick, but Adam's getting sick again. So Adam sees the sign on the door that says we're in a pandemic, and the board encourages everybody to use wipes between workouts, but that's on you. Is that going to be something that's an option? Maybe.
So maybe, but here's what I would say to that. We know what those disclaimers will do in the non-pandemic times, right? We know how it'll work for pools because we have case law we can look back to. We have experience we can look at. We know that for most non-severe illnesses, and not even though they're contagious, using the wipes in the fitness room is enough. And that's reasonable for a board to rely on that. But when we're talking about a pandemic and we're talking about uncharted territory that we don't know any way how courts are going to look at this, we don't know what's going to come out of it. I think we have to be a little bit more cautious. And I don't think we can just compare it to other times or other issues, other disclaimers, because we're not necessarily comparing apples to apples. We're comparing apples to oranges.
And I also think it depends on which direction you're starting from. If you're starting from the direction of we want to keep our residents and our owners safe, then I think that leads you on a completely different analysis as opposed to we want to open the pool as soon as we possibly can. So I think you got to start with the idea of we want to keep our residents and our owners safe, and let that be the lead as to what your conclusions are, as opposed to we want to open the pool. Because if the focus is solely on we want to open the pool, we're going to spend so much time saying, well, can we keep people 6 feet apart? Should people be swimming with masks on? You know, how often do we have somebody in the locker room? Just the amount of concern that you have. And again, if an association's sole focus is will we be held liable or not held liable, like Gabby said, we don't know. Maybe everyone will be held liable, maybe nobody will be held liable. But it's really not that satisfactory of an answer to say, well, guess what? You weren't held liable, but 15 people in your building all got sick from using the pool.
Was it really worth it? Should you really do that? Should you really become that police officer that is monitoring, oh, you're not 6 feet apart at the pool? Should you really undertake that? And is that, I believe too, that the thought process is very different when you're under a stay-at-home order versus as we see modifications to the order. So that's why I don't know, Pat, if you and Adam, if you guys agree with this, but today this is our opinion. And it may change as we hopefully get to new phases under the state and the federal guidelines. But I don't think it would be helpful for any association to be more laxed than what the state is telling us to do.
We're starting to go into a territory that I think is an interesting question as well, and that's enforcement. And because the point that we're starting to get to here is that the board wants to keep everybody safe, but the board can only keep the residents safe by keeping the facilities safe, correct?
Right. Correct.
They can't be policing everybody.
Right. Well, and I think that's the real problem that we're about to undertake. And even as we talk about the pool and the fitness center, you know, the governor's order only applies to public places, right? Even wearing masks, you only have to do that in a public place. But when we're talking about associations, those aren't public. Those are private. That's private property. So I've had many clients who have said, well, so why adopt these rules? Why can't we say everybody has to wear a mask? Why can't we say you can't have outside visitors? You can't have in-unit construction, whether it's essential or not. And the answer to that, in my opinion, is that yes, you could adopt those rules. You could say, we're going to make rules that pertain to our private property, and we as a board clearly have the authority to do that under the state statutes and under our governing documents. But then it goes back to, Brandon, what you were just talking about, enforcing it. Because when you start to enforce it, are you really acting as a board of directors for an association? Or are you acting as somewhat an enforcer of the governor's order? And I think that's where it becomes very, very tricky, because you as a board only have the authority to exercise your powers over the common property, over the property within your association, but you can't control me as a person, and you can't control my health. I have some choices that I can make on my own, and it's something that boards have to be very, very careful about. I think boards should be taking the position that is consistent with the executive orders in place, that is consistent with what Pat said, protecting the safety and the health of your owners. But I think when you go towards enforcing it, that's a bit different. I don't think boards should be fining owners who don't wear a mask, even if there's a sign in the common area that says you should be wearing a mask. I don't think they should take on that role, because in essence, it's kind of a backdoor way to enforce the governor's orders, which clearly state only state and local authorities can enforce his orders.
To add to that too, it doesn't mean that if you see, someone not wearing a mask or, in public outside of the building, call the police. That's the enforcement mechanism. It doesn't mean do nothing, but
right.
We've recommended to some clients, if you see something, of course you can call the authorities.
Well, I think you also need to, we keep saying boards should be thinking about can you versus should you. Boards need to teach their owners that as well. And fortunately, a lot of owners have been very responsive to that. I know that I've talked to managers who've had owners who want to continue with in-unit construction. That's one of the hottest areas, right? And the executive order does allow construction work to continue. But should you, if it's not essential? Should you have more people in your unit in our common areas that are necessary? You may be able to, but should you? And most of the time, the answer is no. And you'd be surprised, and I'm happy to say I'm surprised, but I'm happy to see more that owners are listening to it. They take a step and realize, you're right, we shouldn't be doing that. And I think helping our owners to understand where boards and management are coming from with these policies will likely help everybody to work together. And if they all know that our mindset during these issues is really can versus should, common sense, being reasonable, we're going to probably get more owners to work and to be consistent than we have in other issues as well.
Well, and this isn't anything new, because anyone who's ever been on a board or been at a board meeting or an association meeting knows this. Don't let that one or two people demanding something jeopardize the rest of the building, because like Gabby said, most people are following the rules. Most people are concerned. Most people are working through this. So saying, oh, well, we're hearing from people that they really want to do this, assess what hearing from people means. The same 2, 3 noisy people who complain about everything, yeah, they're going to complain. And this is just another reason for them to complain. Don't let them be the guiding force by which you make your policies.
Well, it kind of goes back to what Adam said before, our great time, our great chance right now to kind of fix some of the mistakes we've made in the past. Sure. I think, Pat, you bring up a great reminder. This is the time to get control over those chronic naysayers. And, you're never going to make everybody happy. So you as a board and management need to decide what's going to govern you, what's going to control you. I think that what's really important to remember is how to balance all of this. And there's only so much you can do. Let's talk also too, we also have a lot of issues as it relates to open houses, showings, that kind of go along those same lines. It's really not for the board to decide what efforts I'm going to take to sell my unit. But fortunately, the Illinois Department of Commerce and Economic Opportunity has spoken, and obviously virtual showings are preferred. There's no open houses are permitted. Showings of vacant or owner occupied units, they are allowed if necessary, and they're scheduled. So boards should require that if somebody is going to conduct a showing, schedule it. We need to know. And no more than 4 people are allowed during a showing. Nothing wrong with the board saying, we don't want showings. It goes back to the difference of saying it versus enforcing it and not allowing people to come in to have a scheduled showing. You really need to stop and take a step back. What are you trying to prevent? What is it that they are allowed to do legally, and how do you balance it? And again, most owners will work with you in scheduling it, saying that, yes, our realtor and those people coming to see it, they'll wear masks. We will let you know as they come in. We will let you leave. And most people want to work together because they too don't want to get sick. And so we just have to remind everyone, we're trying to balance everybody's rights as it kind of all keeps going through. I think too, one thing to remember is if you have on-site employees, the governor entered a requirement on April 30th that there's a notice that needs to be posted for on-site employees. It just kind of reminds them of what their rights are as an employee. So if you have an on-site management office, you're going to want to make sure that you display the workplace health and safety guidance for employees that was generated by the governor's office dated April 30th. It's just another notice, and this applies to all employers. I think those are the rest of our issues that we had open-ended.
All right.
Brandon, do you have any other?
We do have a circle around back to elections questions. They're both centered around. Oh,
Brandon, before you get into those questions, can I just say one thing about those elections? Because when we were having our technical difficulties, the 3 of us had a nice little exchange that was just between us. And so I think we just had some reminders that might be helpful if we kind of reiterate it to everyone. We were talking about this is really such a time that when you're dealing with elections, you have to be creative. And like Pat, you can be creative and legal at the same time. And we were saying that all of us have seen bylaws and rules that really don't allow for secret balloting or don't allow for when there isn't an in-person meeting. But when you take this time to take a step back and look at the rules, there are ways that you can come up with that are creative and still legal with proxy voting, making sure that the people know who will be a good proxy holder that they could name, someone that they know will be there so their vote counts. How can we deposit proxies at the meeting in a safe, secure way so that I'm not feeling that I'm being exposed to the virus, but I can still give my proxy so that the vote can count? And one thing we were also saying was that, it's just so important that while in March we were saying, yeah, cancel your meeting, reschedule it for later, we have to be ready for this is going to continue. And Pat made the point during our conversation, maybe we'll get better towards the end of the summer, but we might see this resurface again later in the year or next year. So you want to have a process in place that shows your owners we can continue to conduct business and we can continue to have our association continue to meet, to have elections, and to move ahead.
Okay. So the questions were, and this might be a technical question that we just have to defer and say don't have the answer, but as far as online elections processes go, Are there any that are typical if you're doing it virtually? Like, I think the examples were a Zoom or is just over an email. What would be maybe some typical online ways of going about it? And the other one we'll save until after that.
Well, I don't think there's necessarily a standardized format. I think it gets back to what we were talking about earlier. What are we going to do to allow people the best means to participate? So when you look at the statute and it talks about acceptable means of technology, it basically refers to some level of commonality, something that people are used to using. So there's ways to use Zoom and GoToMeetings where people can also use their phone. And even if they can't use a video source or something like that, they can use a phone number or they can connect by other means. So I think boards need to figure out what's the best way to allow members to participate. And again, focus on giving them adequate notice so they have an understanding of how to participate. I do think that a lot of times our communities say, well, our members aren't going to do that. Our members aren't used to that. The people who live in our community are too old. They're not used to that. You know what? That's not true. All of those people are on Facebook calls and FaceTime and Zoom meetings with their grandkids and their other relatives right now. We've all started to figure this out. Is it perfect? No. Are there glitches? Yes. Things happen. But work through the process in order to allow people to hear one another, hear what's going on, and know that, okay, I've been a part of this meeting. But I really do think, if anything, this has hopefully kind of forced some of us into technology that we otherwise weren't using. And then when we finally get there, we could say, yeah, it's not as difficult as I thought it was. I figured out a way to make it work. Yeah, maybe I got hung up on 3 times to begin with, but I eventually found the right number and dialed in and oh, look, I can see so-and-so over there and there and there. And I figured out the right button on my computer to finally project myself by video. And even me, I muted myself for a while. I figured out a way to unmute myself. So that shouldn't be that big of an impediment. Work with people to make it happen.
Yeah, I think that's really good. I think I like that your response is that people know. Basically, it's okay, boomer. we can do this.
Well, and you can take into consideration your association and what you think they would like with some of the different technology that's out there. But Pat's absolutely right. I mean, you've got to get out of the comfort zone. We all are getting out of our comfort zone. Even doing this presentation like this is getting us out of our comfort zone. But you have to be, when you can show your community that you are looking outside of the box and you're looking to keep them incorporated and you're looking to keep this business moving ahead, you are only going to establish credibility. And I think that's so important, especially during a pandemic, to show your owners we can handle it and we can protect your asset and we can continue to run your business.
All right. So I think we have one more question on elections, and this will be our last question for today, and then we'll just have some wrap-up closing thoughts. And that is going back to your explanation of ballots versus proxies, Pat. This one asks if there's some combination of the two. Can there be a proxy form which includes a ballot and have that be a mail process?
No. Yes and no. So are there? Yeah, we've seen a lot of them. I'm sure both Adam and Gabby have walked into meetings and been told, well, this is our ballot proxy. And we look and go, oh, geez, ballot proxy, what is that? Because technically that doesn't mean anything. So not to be super technical, a proxy is I have a vote and I am giving my vote by written instrument to another individual who will appear at the meeting and cast my vote in my stead. So that's the function of a proxy. Now, does the proxy directive? Sure. I could tell that person, I want you to vote for A, B, and C. And the limitation on my giving you that proxy is that it's directive. I want to tell you how to exercise my right to vote. And I think this is where a lot of times people get confused with, well, it's a ballot, right? No, it's still a proxy. I'm giving you my right to vote with this type of instruction on there. It's not just open-ended where I give Gabby my right to vote however she thinks is the right way to go at the meeting. I could give Gabby my right to vote for this candidate, and this candidate. A ballot is something different. A ballot is something that I am casting. I don't need a second person involved. I don't need to give that to anyone. But under the Condominium Property Act, there's specific provisions as to when and how to adopt this mail-in ballot procedure. So you have to look in your association's records and documents to say, are we using proxies or are we using ballots? I hope I didn't make that too convoluted. Gabby and I'm seeing Adam and Gabriella, and I keep combining
it like a proxy ballot.
Yes, making it into Gabby. Sorry.
That's okay.
Gabby and Adam, either one of you want to add to that?
No, I think your explanation was a good one. And I think, remember it, everybody, is that a proxy and a ballot are not the same thing, but you can still get creative with proxies on how they are delivered to the association. Because I think that most associations allow proxy voting and not as many have adopted ballots before. And that's where we could still make it work for associations during this time. But I think you did a good explanation for it, Pat.
I agree.
The difference is, remember, because of the date, the 120-day rule, and that's why we are a little hesitant when people just want to vote by by ballot, because not a lot of associations have that rule in place.
All right, so then I think we are on to our wrap-up, our closing thoughts. So any important points from today that you want to make sure you drive home, or anything about the pandemic in general that you guys want to share? Let's go in reverse order for this one. We'll start with Adam, we'll go to Pat, then we'll go to Gabby. So Adam.
I think I would want to hammer home the idea of being proactive and using common sense, and to ask yourself the question of not only can we do this, but really should we do this? And keep in mind health, safety, and what is going to go along with enacting a new policy. Do you really want to be the police enforcing this? So keep those in mind. I think those are good touchstones for any issue that is going to come up. And also just realize that things are going to change. You're going to need to be flexible because new information is coming out daily and we don't know when exactly this will resolve.
Yeah.
I think while there's going to be a lot of change and there's a lot of restrictions and there's a lot of things that we couldn't do them the way we used to do them, as we always see in the law, just because you used to do something for a long period of time doesn't mean it's the right way to do it, doesn't mean the way you should continue to do it. Use this. This is a very difficult time for everyone. So to the extent we can take anything positive out of this, use this as an opportunity of how we can change the way we run our association's operations to better employ technology, to make it more accessible for more owners to participate in the process, be it voting or attendance of board meetings. Use that so years from now we can say we took this time and we actually made running an association better, and more people were aware of what was going on, and we had less people coming to meetings saying, I don't know whatever happens in this community, because you can dial in, you can call in, you can video in, you can vote online, you can participate through electronic notice. We can do all of these things. A lot of these things are already in the statute. Let's start using them.
Yeah, I think both Pat and Adam gave great advice. I continue to guide my thoughts and process with the you can do it, but should you do it? And I should give credit where credit is deserved, that I didn't just come up with that, because like you all, we as attorneys are also educating ourselves. And I had participated in a webinar through National, and that's where I learned it very early in the pandemic. One of the attorneys on the program had said, that's what should guide us. And I thought it was such great advice. And I think it goes along with everything that Pat and Adam said too, because it's when you can do something, but should you do it, it really helps you to think about what makes us better. And I agree. I think that there's a lot of good that can come out of this if we take a step back and think about what we should be doing, how to be reasonable, how to be using our common sense. And the only thing I would add is not to be heavy-handed. This is a time more than ever that we all have to remember we're just managing associations. We're not managing a state. We're not managing a country. And we shouldn't take on more than we've been elected to do.
Great. All right. So then I guess my closing thought is just thank you to everybody. Chat, I appreciate you. Thank you for the questions. Thanks for hanging in there with us. Thank you to Gabby, Pat, Adam. You guys have been such a great resource today for everybody. And the CAI Illinois, thanks you for helping us get that information out there to everybody. So thank you.
Well, thank you. Thanks to everyone.
Thank you.
All right. So for you guys to know, this is going to be available as soon as this broadcast ends. You're going to be able to watch it back here on the CAI Illinois YouTube page. You can watch it anytime on demand. It'll even show the chat on the side yelling at me about audio questions the whole time. And then also I'm going to edit it up nicer so that it sounds better when we release it tomorrow as a podcast episode on the Common Interest podcast. So some of that information will be on the rolling ads here after the presentation ends, so that you're able to see that where you can find our podcast. And until our next thing, I mean, we're going to have another live stream on Friday. We're doing an HOA Q&A focused at homeowner leaders. So if you're on a board, if you're a board member, make sure you tune in at noon on Friday. We're going to have another Q&A session. A lot of great panelists on that one as well. And keep looking for us. We're going to keep trying to get information out there. So until next time, have a good one.
Well, thank you. Thanks for having us.
Thank you very much. So long.
Bye, guys.